Hey, so I'm completely exhausted. I drove to Tunica today with my older son. My younger son, um, he died like on January 27th, and I think today's February 12th. I basically just am in a daze. But I saw that I didn't read the brief, but I saw that these attorneys, Ellis Stern and Goldberg, I don't even remember his first name, Alan Goldberg. They're attorneys in Los Angeles who do estate planning, like estates and trusts, and some LLC work. And they, oh my God, like they're just insane. I I would, I don't know, incompetent or unethical, but so there's this case going on, and the I'm the plaintiff, and it kind of stems from uh, Mr. Stern telling my sisters and my mom. My mom's not even a member of this LLC, but she kind of pulls the strings in the background because, uh, well, she has a lot of money. So my sisters all do whatever she tells them to. And it's a lot of weird family dynamics because my oldest sister, Mary Sherman, is married into the Sherman family with Jeff, Biff, David Sherman are the three brothers, and Mel's their dad, and he started this company that like their family businesses. Anyways, Mary kind of has some extra pull with my mom, so there's this whole weird dynamic going on, and they all decided somehow that they were going to underpay me distributions on this LLC. That's what I'm alleging. And it seems pretty obvious because they were paying me amount that made me think the property was worth about $7 million, maybe $7.9 million. And then when my second oldest sister, Roberta, who was also an attorney, passed away, well, when she got sick with cancer, they decided to sell the property. I'm guessing just to give her a way to be able to spend her money before, so that it didn't get divided up four ways instead of five if she had died. So they sell the property, and I agree to a price of 7.9 million based on the distributions, and they get like 10.2 million or something for it. And like, that sounds great, wow, I got extra money, and they think I should just be happy with what I got. But I talked to a lawyer named Michael Early who went to Stanford and Hastings, and he's had 25 years of experience. So I talked to him, and he takes this case for me, and it seems like it's a pretty cut and dry. He took the case on contingency, so it seemed pretty cut and dry. If they were giving distributions that indicated a price of 7.9 million, and yet they convinced a sophisticated buyer to spend 10 point something million, then it seems like the distributions that I was getting were shortchanging me. Okay. Well, Mr. Stern is supposed to be representing the LLC, but he decides he's going to represent my sisters and the LLC. So, all against one member, me. All right, so now I sue them all. And Michael Early pulls out because they indicate that they're going to put up a fight. They're not going to negotiate. They are just going to waste everybody's time. And I guess that's what makes my mom happy. So they'll end up getting a lot more money in the end, because this LLC was a gift from my parents, and it was just a small portion of their wealth. So, if they know that if they could make Sandy happy, they're going to make Sandy happy. Okay. Anyways, I sue them. And I decide to sue the attorneys in a derivative action. And I never even heard of a derivative action. But they were the ones who said, oh no, the suit has to be brought as a derivative action. So I kind of quickly read a little bit about what it is. And I thought, well, no, the whole case is not derivative, but I could put in a derivative action for malpractice against the attorneys. So I did that. Well, then, I hope I'm not losing everybody already, but the attorneys get attorneys to represent them. And there was another attorney involved, but he's finally backed out, and that's why I'm not talking about him. But anyways, their attorneys file an anti-SLAPP suit against me, which means a SLAPP suit is a strategic litigation against public participation. So it's like if I had said, I'm going to sue you for saying that I'm a bad candidate. And it's going to cost you a lot of money to protect yourself. Even though you're allowed to call me a bad candidate. But, just the lawsuit itself is going to kind of chill your freedom of speech. So that's a SLAPP suit. An anti-SLAPP motion is what they did, which is if the person loses the anti-SLAPP motion, then they have to pay attorney fees. And in the United States, typically you don't have to pay attorney fees even if you're the losing party. So here I am, a pro se litigant representing myself, no law school degree, no, I'm not a lawyer, self-taught, and they bring in attorneys to represent attorneys, and they file this anti-SLAPP motion. Well, then I realize, because remember, derivative suits are considered pretty sophisticated, and I didn't realize at first, but I'm not even allowed to file a derivative suit. Anything that I say, because I'm not an attorney, is void. So I don't know why Judge Sammartino, Janis Sammartino, was the first judge, and I don't know, maybe she was busy because her son was in some legal trouble for having sex with a 17-year-old student when he was a teacher at La Jolla Country Day, like a prestigious school in La Jolla. And I don't know that timing coincides exactly, but for some reason, this Janis Sammartino decides that she's not going to say anything about me being a non-attorney trying to represent an LLC in a derivative suit. And on top of that, she agrees with all the defendants that not only is the malpractice, the legal malpractice, a derivative suit, but that everything that I have written is a derivative suit. And so it was thrown out because, not because I'm not an attorney, but because I didn't write it as a derivative suit. So they're saying, you had to write this as a derivative suit because it is one. It's not an individual suit. There's no way that you're going to be able to write this as an individual suit. So you are out. They had a motion to dismiss, and it was granted. But Janis Sammartino doesn't say, oh, this derivative suit, the legal malpractice and everything else that you wrote was written by a non-attorney on behalf of an LLC, so it's all void. No, she doesn't say that because, well, frankly, she's trying to drum up money for her attorney friends. They don't like pro se litigants. I'm going to just say she's a bitch. I guess if she was a man, I'd say he was an asshole. But whatever. She's not a nice person. She obviously raised a son who was not a nice person, though, I mean, I guess a parent can't be held responsible. Like, my son was a drug addict, but I didn't have anything to do with that. Anyways, it's a different story. But sometime come back and listen. I'm going to talk a lot about Buddy and how he had his life ruined. Some of it by Mary Sherman and Jeff Sherman and their friend Ellen H. Friedenthal. But anyways, I'm digressing again. So I file a motion to withdraw this legal malpractice part of the case. And Judge Sammartino says, yeah, go ahead. And I clearly stated the reason was because I'm not an attorney and I can't legally, like, if they had thought of it, they could have just slapped the cuffs on me right then, tossed me in jail for practicing law without a license. But they didn't do that. And, you know, they shouldn't have. I'm kind of saying that tongue in cheek because, like, there was no intent to I didn't know I was committing the crime, and The moment that I found out that it was, I said, hey, I'm not allowed to do this. So, okay. So she says, yeah, you could withdraw. Oh, but by the way, you're going to have to pay their attorney fees, because if you withdraw after they file a motion, anti-SLAPP motion, then you're presumed to be the loser. She cites one of her own cases. It's not case law, it's not precedents, but there is some authority to, cases that are not decided by the appellate courts. Anyways, she cites her own case, but she leaves out that even in her own case that she's citing, that she had mentioned that you're presumed to be the loser unless you gave a reasonable reason, that was not that you're the loser, but that you had to withdraw. And I did that. I mean, is she telling me that I should have just not withdrawn and just gone on and committed this crime? Oh, that's back to, like me committing this crime, is that I asked Judge Sammartino to let me have an attorney to explain derivative actions and to help me on things that I could not do myself, but only like partial representation. It's called limited representation. And she said no. And I asked her again, and she said no, you can't have somebody help you. So I actually did try to not do the derivative action myself. And she insisted that I do it myself. And then when I withdrew it, she said that I had to pay their attorney fees. Okay, so now let's get to problem 2. That wasn't confusing enough. It goes through years of litigation, not accomplishing anything. I just keep repeating myself, and Judge Sammartino gets transferred off the case, and this new judge comes on, and his name is Todd W. Robinson. And then later he gets substituted by a Democrat one, Linda Lopez. And all of them just keep upholding and denying me reconsideration. And so I finally take it up to the appellate court, Ninth Circuit. It sits on their desk for like a year, I don't know, really long time. And then they come back and say, oh, and I had tried to go to the appellate courts earlier, and they said, no, you don't have a final order, so we're not hearing this until you have a final order. So I had tried to go to the appellate court, to the Ninth Circuit. They said, no. Now I'm at the appellate court. I write this beautiful brief, full length. They respond, full length. Everybody's, going back and forth. The Ninth Circuit says, oh, we have to dismiss this appeal and the whole case because, well, we want you to tell us what you think about this. do we have to dismiss everything? Because Laura lives in Arkansas, and she's doing this on a diversity jurisdiction. And diversity jurisdiction doesn't exist if there's any defendant who also resides in Arkansas. And the LLC, because of this case called Carden, Carden, I forget the whole citation. I'm doing this all without notes. I'm in a hotel room. I came out here to play poker with my son. But anyways, so they say, what do y'all think about throwing this case out because there's no diversity of jurisdiction, because the LLC has citizenship in every state of every member. So since Laura is a citizen of Arkansas, the LLC is a citizen of Arkansas. And they're right. But the LLC attorneys, Stern and Goldberg, and when my past lawyer filed a lawsuit, Stern and Goldberg turned everything over to another lawyer. That's the one I had mentioned earlier, Patrick McGarrigle, and his firm has McGarrigle in the name. It's basically just him. And the lawyers, so McGarrigle has has attorneys, and Stern and Goldberg have attorneys, and then each of my sisters got separate attorneys, and all these attorneys and 3 judges never mentioned Carden or the lack of jurisdiction. And even after the Ninth Circuit came up with that, which I think was an excuse so that they didn't have to say Laura's right, they're all still fighting it, saying, no, the LLC doesn't have citizenship in Arkansas because... And then nothing makes sense, but they're just... Okay, another word that probably is not a legal term, but this is just like the biggest clusterfuck that has ever happened. So, oh my God. Now, Stern and Goldberg, McGarrigle back down. I mean, he's still, unless I get it overruled by the appellate court, I still owe his attorney fees. But Stern and Goldberg have been racking up the attorney fees on the appeals. McGarrigle, at least his insurance company, decided that it wasn't worth it. So they backed out. And, I mean, that's the funny thing about it, is everybody's got insurance and they're fighting like tooth and nail. They won't tell me who the insurance companies are, but this whole thing is just crazy. And I guess that's it. Just the fact that I wasn't supposed to be arguing any derivative action. So if they want to say that any part of it was derivative, that part is completely void. And it's as if it didn't happen. They can't have it both ways. And then, oh, this is the really funny part. Okay. So this Todd W. Robinson, he, upholds what went on with the attorney fees for the anti-slap. And then I find a case. I don't remember the name of it. I'm so sorry, but you could look up the documents in this Hammett v. Mary Sherman et al. Or maybe I'll put it in the description or something. But anyways, Judge Robinson had this exact thing happen where there was a jurisdictional issue, but instead of just getting the case thrown out on a jurisdictional issue, which is really easy, like 2 pages tops, this party filed a anti-slap suit, and it went on, they racked up fees, and Judge Robinson tells them that they're jerks, that they wasted everybody's time, that they should have just said there's a jurisdictional issue and not had everybody do this whole anti-slap thing where you actually have to prove the case, like who would prevail if this went to trial, if it got past the motion to dismiss, who would prevail. So Judge Robinson just chews these defendants out about filing the anti-slap suit. And instead of filing to a motion to dismiss based on jurisdiction, guess what? The defendants were pro se, like me, non-attorneys. The plaintiff, like I'm the plaintiff in this case, the plaintiff in that case was represented by attorneys. So when the roles are reversed, Judge Robinson rules against the pro se for the exact thing that he ruled. He rules against the pro se for the exact thing that he ruled against the represented party for. Anyways, I don't know if I said that right. That's how confusing it is. Well, I'm going to delete all of my ums and hesitations and digressions and use this transcript as kind of the basis of my reply to this response brief that just got filed in the Ninth Circuit. Your tax dollars at work for you.